Good afternoon. It's a pleasure to see so many of you here this afternoon. Delighted at this turnout and delighted that you're here to hear our distinguished speaker today. This is the 99th Sibley lecture that's been delivered at the University of Georgia School of Law, and we're very proud of this tradition and our premier lecture series. The lectureship is sponsored by the Loredens Foundation. It's their generosity that makes these events possible. And the series is named in honor of John Sibley, a 1911 graduate of the University of Georgia School of Law. So again, we are delighted that you're here today. We look forward to today's lecture, continuing this wonderful tradition. And it's my pleasure now to introduce Assistant Professor Kevin Heller, who will introduce our speaker.
Well, welcome everyone. I have the pleasure of introducing our lecturer today, Sanford Levinson. I will be very short and sweet. Sanford Levinson holds the W. St. John Garwood and W. St. John Garwood Jr. Centennial Chair in Law at the University of Texas Law School, where he is also a member of the Department of Government. He joined the University of Texas faculty in 1980, having previously been a member of the Department of Government at Princeton University. He has his law degree from Stanford, a PhD in political science from Harvard, and a BA from Duke University. He is the author of more than 200 articles in journals as varied as the Yale Law Journal, Constitutional Commentary, Law and Contemporary Problems, the University of Chicago Legal Forum, the Georgetown Law Review, Cardozo Studies in Law and Literature, the Harvard Law Review, and of course we could kind of go on and on with the list. He has additionally written several books, including Constitutional Faith in 1988, and Written in Stone, Public Monuments in Changing Societies in 1998. He has also edited and co-edited numerous books, including Constitutional Stupidities, Constitutional Tragedies in 1998 with William Eskridge, and a leading constitutional law casebook, Processes of Constitutional Decision-Making, with Paul Brest, Jack Balkin, and Akhil Amar, which is currently in its 4th edition. Most recently, he edited a collection entitled Torture, a collection for Oxford University Press, which includes reflections on morality, law, politics of torture from a variety of disciplinary perspectives. He has visited at law schools as varied as Harvard, Yale, New York University, Boston University, as well as the University of Paris II, Central European University in Budapest, and the Hebrew University in Jerusalem. Finally, he is a member of the American Law Institute and was elected in 2001 to the American Academy of Arts and Sciences. So, without further ado, please join me in welcoming Sanford Levinson.
I am, of course, highly honored to have been asked to deliver the Sibley Lecture. While thinking these past weeks about what I wanted to talk about with you today, I have found myself retracing some past steps because I find myself ever more perplexed and concerned by certain aspects of our public life, particularly in the aftermath of September 11th. Throughout my career, I've been concerned, and perhaps obsessed is the better word, by what we mean by the notion of fidelity to law, and more to the point, whether we really care about such fidelity. Some 30 years ago, for example, I published a review essay in the Stanford Law Review, Fidelity to Law in the Assessment of Political Activity, or Can a War Criminal Be a Great Man? That examined the relationship, if any, between our esteem for certain political leaders. The article in particular concerned Henry Kissinger and John Kennedy and their fidelity to the norms of international law with regard to the Vietnam War and the Cuban Missile Crisis, respectively. Those interested in jurisprudence will recognize my parenthetical question, that is, can a war criminal be a great man, as simply a variant of the more basic question as to the relationship, if any, between law and morality. Similarly, I have more recently asked this at a lecture at the University of Illinois a couple of years ago, was the Emancipation Proclamation constitutional? Do we, should we care what the answer is? I believe that the Emancipation Proclamation is in fact constitutionally questionable, and that most of us properly don't care if that is the case. inasmuch as the moral value of ending chattel slavery or winning the war, though perhaps in Georgia that might not be so self-evident, overcomes legalistic obstacles. As I originally envisioned my remarks to you this afternoon, I thought that I would go on at this point to explain what it is about many arguments and actions associated with the Bush administration that indeed frighten me as a constitutional lawyer and, more importantly, as a concerned citizen. I increasingly believe that the principal issue before us as citizens of a constitutional republic is whether the United States is careening toward a far more authoritarian mode of governance than we have heretofore accepted as the American way. However, as I thought more deeply about what thoughts I wanted to share with you, I found myself, as I usually do, turning to the history of American constitutional development and discovering, as I usually do, that contemporary debates take on a new and more complex coloration when placed within an historical context. The fact is that a central debate going back at least to the origins of the Constitution concerns the relationship between constitutional restraints and the exigencies presented by perceived emergencies. September 11th is only the latest example of a dire event that provokes both great public anxiety and actions by political leaders designed to relieve such anxieties that, at the same time, call into question the very meaning of constitutional fidelity. What, after all, do we mean by constitutionalism? A variety of answers might be offered, but for most of us, particularly for most Americans, the answer almost invariably involves some notion of limited government and the linked notion of a government of laws and not of men, and today women. That is, we expect our leaders to subordinate their own goals and agendas and visions to the impersonal constraints of the Constitution to which they all take an oath. The central mantra of the founding generation, after all, was that the national government established by the 1787 Constitution was a limited government of assigned powers, a term that I assume is familiar to those of you who have taken constitutional law. And that mantra certainly retains its own power and our own time for each and every one of us, even if, as I strongly suspect, we might disagree on what the most important specific limitations of power are. A key problem, though, is that from the very beginning of our history, notions of limitations and absolute fidelity to law have contended with equally compelling importance of having leaders who are willing to respond to exigencies of the moment and to do what was necessary, regardless of the law. At the ultimate level, after all, one might put the American Revolution in this context. Even more illuminating, at least for lawyers, may be the legal difficulties attached to the formation and the ratification of the Constitution itself. The long and the short of it is that the Philadelphia Convention went well beyond the powers they were given by Congress with regard to suggesting amendments to the existing Constitution, that is, the Articles of Confederation. Moreover, and far more importantly, they simply ignored one of the most interesting aspects of the Articles, Article 13, which said that any amendments to the Articles required the unanimous approval of all of the 13 state conventions. Article 7 said that the new Constitution came into legal being if it got the ratification of only 9 state conventions. Thus, I often teach my own students that if they want to win an easy bar bet, just ask somebody how many states were in the Union when George Washington became President of the United States on April 30th, 1789. The correct answer is 11. North Carolina and Rhode Island had not ratified the Constitution, and it just didn't matter because 9 were enough, and more to the point, the 11 that did were certainly more than enough politically and North Carolina and Rhode Island weren't really that important. I'm from North Carolina, incidentally. I think North Carolina is important, but juridically it was not. How was the transgressive nature of the convention, which was no secret, defended? Speaking to the Philadelphia Convention on June 16, 1787, Virginia Governor Edmund Randolph told his fellow delegates the following, quote, "There are great seasons when persons with limited powers are justified in exceeding them, and a person would be contemptible not to risk it," unquote. 2 days later, Alexander Hamilton agreed, quote, "To rely on and propose any plan not adequate to these exigencies merely because it was not clearly within our powers." Listen to that, merely. Merely because it was not clearly within our powers would be to sacrifice the means to the end, unquote. Many, perhaps most of the framers, were familiar with John Locke's second treatise on government, in which one of the most important arguments concerns what Locke calls prerogative, particularly of the executive. It is true that Locke views governments as instituted to protect individual rights, but this does not entail for him an at all time narrowly limited government. The, quote, "power to act according to discretion for the public good without the prescription of the law, and sometimes even against it, is that which is called prerogative. This power, whilst employed for the benefit of the community and suitably to the trust and ends of the government, is undoubted prerogative and never is questioned," unquote. One is hard-pressed to understand American constitutionalism without including a place for the prerogative of leadership to ignore the law on occasion. Thus, the quotations from Randolph and Hamilton could easily be complemented by similar quotations from such luminaries as James Madison, Thomas Jefferson, Abraham Lincoln, and Franklin Roosevelt. The question, of course, is whether this completes our constitutionalism, as it were, or in fact fatally undercuts it, at least in the more simple versions of what constitutionalism is about. Moreover, consider John Marshall's opinion in McCulloch versus Maryland, a far, far more important opinion than Marbury versus Madison. He pivots his argument on the premise that the Constitution we are expounding is, quote, "a constitution intended to endure for ages to come and consequently to be adapted to the various crises of human affairs," unquote. University of Michigan law professor James Boyd White has described Marshall's opinion in McCulloch, quote, "as less an interpretation of the Constitution than an amendment to it, the overruling of which is unimaginable," unquote. In effect, then, at least according to Professor White, one might see McCulloch as exemplifying a certain kind of judicial prerogative to adjust or adapt the Constitution to the crises of governance. All effective leaders, whether presidents, justices, or legislators, must know, in effect, when to break rules as well as when to follow them. Consider in this context one of George Mason's objections to the original Constitution. Mason, a Virginian, was perhaps the most prominent of the three members of the Philadelphia Convention who refused to sign the Constitution. The usual explanation is that Mason was upset that the original Constitution, because it included no Bill of Rights, raised the specter of a too powerful, unlimited government. This is surely correct, but that is not the whole story. He is critical of the fact that, quote, "both the general legislature," that is Congress, "and the state legislatures are expressly prohibited," unquote, "from passing ex post facto laws," that is, laws retroactively criminalizing behavior. The reason for Mason's unhappiness about the express and categorical prohibition is, quote, "there never was or can be a legislature, but must and will make such laws when necessity and public safety require them, which will hereafter, that is, the making of such laws, will hereafter be a breach of all the constitutions of the Union and afford precedents for other innovations, unquote. Now, Mason is not merely suggesting that it will be unfortunate in the future if state legislatures and Congress find themselves without the power to pass ex post facto laws. Rather, what he is saying is that they will find themselves feeling a necessity to pass such laws, and they will do so. And it may very well be, if he were using the language of a modern, well-trained lawyer, that these laws would be upheld under some compelling interest test. And so what Mason is suggesting, in effect, is that it is dangerous to over-cabin the power of government if it is predictable that if necessities should arise, they will act regardless of what the Constitution seems very clearly to say. Though discussing a different part of the Constitution, Madison makes a similar point in the Federalist number 41. Quote, "It is in vain to oppose constitutional barriers to the impulse of self-preservation. It is worse than in vain, because it plants in the Constitution itself necessary usurpations of power, every precedent of which is a germ of unnecessary and multiplied repetitions," unquote. Madison almost certainly had to agree, albeit reluctantly, with John Marshall's language quoted earlier about the importance of adapting the Constitution when crises presented themselves. The United States Constitution does not, of course, formally recognize the possibility of a mandatory adaptation outside of Article 5 of the Constitution. Indeed, Kevin mentioned that I had co-edited a book called Constitutional Stupidities, and one of the candidates for the greatest constitutional stupidity offered by Steve Griffin from Tulane is Article 5 itself, which functionally makes it basically impossible to amend the Constitution, a subject to which I will return at the very end of my remarks today. The United States not only do we have an amendment process that is very difficult, but the United States Constitution, unlike the Indian Constitution, which allows suspension of constitutional norms in times of emergencies for better and for worse, there is no such power in the United States Constitution granted Congress. Article 1 does authorize Congress to suspend the writ of habeas corpus, which is no small problem, no small power. Yet certainly the most famous and for some notorious such suspension of habeas corpus in our history was Abraham Lincoln's unilateral suspension at the very beginning of the war, an action found unconstitutional to Chief Justice Roger Taney in ex parte Merryman. Lincoln basically ignored Taney's decision, and of course Lincoln is widely regarded as our greatest president, from whom contemporary analysts continue to draw important lessons. Thus, University of Minnesota law professor Michael Stokes Paulson, in a recent article tellingly entitled "The Constitution of Necessity," offers a robust defense of what can only be called executive prerogative. Paulson derives his argument from a mixture of the oath of office plus the actions taken by Lincoln between 1861 and 1865. For Paulson, the oath of office, "I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States," authorizes the President to disregard any particular part of the Constitution if fidelity to the part might threaten the survival of the overall constitutional order itself. Paulson quotes Lincoln, quote, "I felt that measures otherwise unconstitutional might become lawful by becoming indispensable to the preservation of the Constitution through the preservation of the nation," unquote. Paulson endorses Lincoln's metaphor that it is sometimes necessary to amputate a limb in order to save the body. Paulson fully recognizes that he is defending, quote, "dangerous principles," unquote, but he concludes, quote, "if I am mistaken in all this, so was President Lincoln," unquote. As it happens, Lincoln was a figure of great interest to the German legal theorist Carl Schmitt, the most prominent devotee of the importance of emergencies that justify exceptions from ordinary constitutional norms, usually on the part of strong executives. Schmitt, indeed, ended up providing essential jurisprudential support for Hitler's takeover in Germany in 1933. Schmitt referred to Lincoln as a, quote, "perfect example," unquote, of what Schmitt called the commissarial dictatorship. That is, a dictatorship entered into ostensibly to save the existing political order. The American political scientist Clinton Rossiter, who wrote a brilliant and troubling book titled Constitutional Dictatorship, basically agrees. Quote, "The 11 weeks between the fall of Sumter and July 4th, 1861, constitute the most interesting single episode in the history of constitutional dictatorship. The simple fact that one man was the government of the United States in the most critical period in all its 165 years." He was writing in 1948, so today we might say the most critical period in all of some 215 years, and that he acted on no precedent and under no restraint makes this the paragon of all democratic constitutional dictatorships, unquote. As it happens, Rossiter immediately follows this with an all-important caveat, quote, "If Lincoln was a great dictator, he was also a greater Democrat," unquote. But Rossiter concludes his book with this sentence, quote, "No sacrifice is too great for our democracy, least of all the temporary sacrifice of democracy itself," unquote, which, to put it mildly, should give us pause. Questions about the relative rigidity and flexibility of constitutional norms, including the recognition of prerogative powers, can arise with regard both to declarations of rights and to the governing structures of the societies themselves. I will concentrate in my remarks today on the former, that is, notions of right, though one should have no doubt that structures are at least as important as rights, illustrated by the very point that prerogative almost invariably involves assertions of powers by the executive and the relative diminution of power by the legislatures and the courts. With regard to rights, though, one might well begin with the First Amendment, which of course states that Congress shall pass no law abridging the freedom of speech. This is inaccurate as the true meaning of the First Amendment for contemporary lawyers. What has prevailed, for better and worse, is a theory of the compelling interest that can justify deviation from what appears to naive textualists like Justice Hugo Black, the clear command of the Constitution. Were he alive today, he might well continue asking, what part of no law do you not understand? More important, though, is Oliver Wendell Holmes, who had transformed American legal understanding by his forthright declaration in 1881 that the life of the law is experience and not logic, or one might add, the cold meaning of texts. And no experience was more important than emergency, necessity, or crisis. Indeed, it was Holmes who had, in a seminal case that upheld against First Amendment attack, the criminalization of anti-war speech during World War I, Holmes wrote, quote, "When a nation is at war, many things that might be said in time of peace are such a hindrance to its effort that their utterance will not be endured as long as men fight, and that no court could regard them as protected by any constitutional right," unquote, whatever the First Amendment says. Similarly, one might consider a text from the original Constitution, the Contract Clause of Article 1, Section 10, quote, no state shall pass any law impairing the obligation of contracts, unquote. Again, one might ask what part of no state shall pass is ambiguous. By happy coincidence, what I personally believe to be the greatest single set of opinions in the history of the United States Supreme Court was delivered in a 1934 case, Home Building and Loan Association versus Blaisdell, that examined the meaning of the contract clause. Chief Justice Charles Evans Hughes' superb opinion for the 5-judge majority is followed by an equally well-argued and gripping dissent by Justice George Sutherland for the 4 dissenters. But Blaisdell, in fact, is about far more than the contract clause. In effect, it asks whether the social and political instability of the Great Depression and emergency justifies de facto suspension of the contract clause. One of Carl Schmitt's most quoted maxims is that, quote, there exists no norm that is applicable to chaos, unquote, or perhaps even crisis. Hughes need not have been familiar with Schmitt in order to recognize the general debate then occurring throughout the West about the ability of traditional notions of the rule of law to survive the Depression in the context of what my colleague Philip Bobbitt calls the nation state and its relatively newly embraced duties to concern itself with the economic welfare of its citizens. Depressions were not new in American life. What was new was the view that government had the duty to exhibit real concern for the economic welfare of the losers during depressions. The Minnesota legislature passed the Minnesota Mortgage Moratorium Law in 1933 in response to what it explicitly referred to as the, quote, emergency, unquote, generated by the Great Depression for homeowners. As banks started foreclosing loans upon failure to meet the obligations of the mortgage, the Minnesota legislature intervened with a moratorium law, which basically freed beleaguered homeowners from the burden of their contract to pay, as mortgages were then written, large balloon payments at the conclusion of the term of the mortgage. So long, instead, as they continued to pay a reasonable rental value of the home, they could remain in it. The act was to remain in effect, quote, only during the continuance of the emergency and in no event beyond May 1st, 1935, unquote. The Home Building and Loan Association, after foreclosing the mortgage on the Blaisdell house, bought the property at the foreclosure sale for approximately 2/3 of its market value. However, under the Minnesota law, the Blaisdells had until May to redeem their home by paying the association a little bit more than $4,000. The Blaisdells were required in the interim to pay a fair market rental value of $40 a month. The bank argued, understandably, that the moratorium law was in clear violation of the clear words of the contract clause. No state shall pass any law impairing the obligation of contracts. The Blaisdells' obligation was to pay off their mortgage in 1933, not in 1935. Both the Minnesota and United States Supreme Courts upheld the law against the bank's challenge, even though no one seriously argued that Minnesota had not impaired the association's obligation of contract, actually the Blaisdells' obligation of contract. But for the Minnesota Supreme Court, this was basically beside the point. Times were perilous. After offering a summary of the ravages facing the state and nation, it concluded that the, quote, the court cannot well hold that the legislature had no basis in fact for the conclusion that an economic emergency existed which called for the exercise of the police power to grant relief, unquote. Chief Justice Hughes, as I say, wrote the opinion for the majority of the court in Blaisdell, and he agreed that the case required the court to, quote, consider the relation of emergency to constitutional power, unquote. And then he wrote the following oft-quoted paragraphs, quote, emergency does not create power. Emergency does not increase granted power or remove or diminish the restrictions imposed upon power granted or reserved. The Constitution was adopted in a period of grave emergency. Its grants of power to the federal government and its limitations of the power of the states were determined in the light of emergency, and they are not altered by emergency. If you read only this paragraph, you might well think that the bank was on its way to victory. Then Hughes goes on. While emergency does not create power, emergency may furnish the occasion for the exercise of power. Although an emergency may not call into life a power which has never lived, nevertheless, emergency may afford a reason for the exertion of a living power already enjoyed, unquote. Hughes concedes that no prior case justifies, quote, a construction which would permit the state to adopt as its policy the repudiation of debts or the destruction of contracts or the denial of means to enforce them, unquote. But he insists that is not the case here. Instead, he argues that acceptance of this general principle does not apply under conditions when, quote, a temporary restraint of enforcement may be consistent with the spirit and purpose of the constitutional provision, unquote, which he says is to preserve a functioning economy. Quote, it cannot be maintained that the constitutional prohibition should be so construed as to prevent limited and temporary interpositions with respect to the enforcement of contracts if made necessary by a great public calamity such as fire, flood, or earthquake. The reservations of state power appropriate to such extraordinary conditions may be deemed to be as much a part of all contracts as is the reservation of state power to protect the public interest in the other situations to which we have referred. And if state power exists to give temporary relief from the enforcement of contracts in the presence of disasters due to physical causes such as fire, flood, or earthquake, that power cannot be said to be non-existent when the urgent public need demanding such relief is produced by other and economic causes, unquote. It ought to be crystal clear that Chief Justice Hughes, like presumably the other four justices in the majority, basically agreed with the Minnesota legislature about the exigencies of the moment and the need for governmental action. My confidence is based on a single sentence, quote, it is always open to judicial inquiry whether the exigency still exists upon which the continued operation of the law depends, unquote. Blaisdell, then, is not illustrative of judicial abdication of reviewing authority and a concomitant rubber stamping of legislative action. Indeed, the court itself must determine whether the exigency still exists that justifies the extraordinary action, however it is described. This may be no small point, as shall be seen presently. Justice Sutherland wrote a probing dissent based largely on the text of the contract clause and the original intent of its supporters, who saw it precisely as a way of heading off debtor relief legislation, which they were well familiar with in states like Rhode Island. Sutherland concluded his dissent with these ringing words, quote, whether the legislation under review is wise or unwise is a matter with which we have nothing to do. Whether it is likely to work well or work ill presents a question entirely irrelevant to the issue. The only legitimate inquiry we can make is whether it is constitutional. If it is not, its virtues, if it have any, cannot save it. If it is, its faults cannot be invoked to accomplish its destruction. If the provisions of the Constitution be not upheld when they pinch, as well as when they comfort, they may as well be abandoned, unquote. If one sentence can be said to capture the essential dilemma of constitutionalism, it is surely this last one. What do we or should we do when we find that the Constitution pinches instead of comforts? I now turn to our present situation. On the one hand, I believe that the Bush administration threatens our basic constitutional order more than any other administration in my lifetime. On the other hand, I confess that I have some difficulty constructing a satisfying language in order to make the argument. Or, more to the point, it is unclear to me whether my criticisms follow from what might be termed my professional expertise as a professor of constitutional law, or rather reflect my politics as an admittedly very partisan Democrat. Normally, my own political identity would be an inappropriate topic for discussion in a lecture like this one. However, I increasingly believe that the discussion of emergency powers is ultimately a profoundly political one, with law, at least as traditionally conceived, having relatively little to do with the resolution of any truly live controversy. Consider just for the moment our assessments of Thomas Jefferson's betrayal of his own constitutional vision in order to purchase Louisiana, which is in fact not only Louisiana, but the entire Midwest going all the way over to Montana, and Abraham Lincoln's willingness to act extra-constitutionally, if need be, in order to preserve the Union. Can one possibly decide whether to condemn either of these distinguished presidents or many others who could be offered without taking a political stand on the merits of the purchase or the preservation of the Union? My title refers to the possibility that we live now in a world of permanent emergency. I think that is true for reasons I shall elaborate in a few moments. But it should now be clear that in some ways our entire history as a nation has featured the presence of emergencies, even if no single emergency has had the permanence likely to be the case with the so-called global war on terror. But an impressive or depressing number of years of our national life have been spent fighting wars, some declared, many more not, against foreign enemies, our fellow American citizens between 1861 and 1865, or myriads of American Indians who had the effrontery to resist our seizure of their homelands. And of course, as Blaisdell itself illuminates, economic troubles generate their own sense of emergency with concomitant use of governmental power, particularly following the triumph of the welfare state, as I described it a few moments ago. My own life, which began in 1941, has been spent in wars, whether of the shooting kind, as in World War II, Korea, Vietnam, Iraq, Kosovo, and Iraq again, or the cold kind, as with the Soviet Union, or the more metaphorical but no less constitutionally significant kind, such as our war on drugs that has operated to limit many of our constitutional rights against aggressive police behavior. Even were the global war on terror declared over tomorrow, there would be more than enough emergencies to assure that the basic tension of which I'm speaking would remain. So, on to the Bush administration. I have already indicated my belief that, or I have written other places, my belief that the best entry point into the jurisprudence of that administration is in fact Carl Schmitt, who elaborated a powerful theory of an executive dictator who would serve as, quote, guardian of the Constitution, unquote, or perhaps more accurately, the nation against attacks by its enemies. An essential function of the executive is, in effect, to seize the most basic attribute of sovereignty, which, according to Schmitt, is the ability, quote, to decide on the state of the exception, unquote. One should recognize that what begins as the exception can quite easily, over time, be redefined as the new normal. Thus, says Schmitt, quote, a normal situation has to be created, and sovereign is he who definitively decides whether the normal state actually obtains. All law is situation law. The sovereign creates and guarantees the situation as a whole in its totality. He has the monopoly on this ultimate decision, unquote. I believe that it would be a profound, wishful mistake to believe that Schmitt can simply be dismissed as a Nazi-sympathizing, anti-Semitic fascist, though this may well be an all too accurate description of his politics during the 1930s. I alluded earlier to the American political scientist Clinton Rossiter, who ironically is probably best known as the editor of the most widely used version of The Federalist. His 1948 book, Constitutional Dictatorship, which perhaps tellingly was republished after half a century in 2002 with a cover picture showing the burning Twin Towers juxtaposed with a seemingly burning Constitution, has distinctly Schmittian overtones. Quote, a great emergency in the life of a constitutional democracy will be more easily mastered by the government if dictatorial forms are to some degree substituted for democratic, and if the executive branch is empowered to take strong action without an excess of deliberation and compromise, unquote. An executive branch that believes itself, quote, empowered to take strong action without an excess of deliberation and compromise, unquote, is, I believe, an almost perfect description of the Bush administration. The defining feature of this administration, evidenced, of course, in the recent presidential election, is the centrality of the global war on terror and the associated freedom this is thought to give the president to make any decision he seems suitable with regard to carrying out that war. The freedom applies both to what is sometimes called the war of law and the war in law. As to the first, President Bush has basically claimed a monopolistic ability to decide when and against whom the United States shall unleash military power, regardless of what Congress, or even more certainly the United Nations, might think. In fairness to President Bush, not only were similar claims made by his father at the time of the first Iraq War, but just as significantly President Clinton, who also sent troops to Haiti and went to war in the South Balkans, did not bother very much about either congressional or United Nations authorization. As to the law in war, surely the most important debate concerns the propriety of torture. There are two great debates about torture. One of them involves how we define the term. That is a very important topic about which I've written elsewhere and is not part of my topic today. This is not true, however, of the second debate, which involves the extent to which the executive branch is bound by international and domestic law prohibiting torture, however one defines torture. One should begin by emphasizing that federal law clearly and unequivocally bars the use of torture by any official of the United States without exception. This should scarcely be surprising insofar as the United States Senate ratified, in the name of the United States, the United Nations Convention Against Torture, Article 2 of which states not only that each state party shall take effective legislative measures to prevent acts of torture in any territory under its jurisdiction, but also, and more interestingly, that, quote, no exceptional circumstances whatsoever, whether a state of war or a threat of war, internal political instability, or any other public emergency may be invoked as a justification of torture, unquote. Moreover, Article 3 states that, quote, no state power shall expel, return, or extradite persons to another state where, according to language added by the Senate, it is likely that there would be a danger of being subjected to torture. It would seem, therefore, that the President's Article 2 duty to take care that the laws be faithfully executed would make invalid almost any argument that he has the authority to order torture or even to render suspects to countries where torture is commonly practiced. This is not the position of the Bush administration, at least from August 1, 2002 until December 30th, 2004, when the earlier memorandum was withdrawn. In that earlier memorandum, the Office of Legal Counsel construed the President's authority as Commander-in-Chief to include the overriding of any such apparent barriers to torture. That is, quote, in order to respect the President's inherent constitutional authority to manage a military campaign against al-Qaeda and its allies, statutory law must be construed as not applying to interrogations undertaken pursuant to his Commander-in-Chief authority, unquote. That is, it would be unconstitutional to limit the President's ability to authorize torture. As it happens, this discussion of the Commander-in-Chief power was eliminated from the December 30th, 2004 memorandum, but the administration and its new Attorney General, Alberto Gonzales, never repudiated the discussion in the way that it did explicitly repudiate the extraordinarily narrow definition of torture that was part of the earlier memorandum. Instead, the administration's position is that discussion of the President's legal authority to order torture is irrelevant because the United States simply does not torture or render persons to countries where it is expected that they will be tortured. This is almost certainly a lie, though sad to say, very few people seem to care. I have no doubt that the administration's position is precisely that set out in the withdrawn memo, though it is now what might be termed a secret position. Consider this, however. If the President is authorized to engage in unilateral preventive wars or to authorize torture, then are there any limits to the President's emergency power? Charles Evans Hughes once notably stated, quote, "We live under a Constitution, but the Constitution is what the judges say it is," unquote. is what might be termed the Bush corollary, but not only Bush, the presidential corollary, if one wants to be a bit more generous, that we live under a Constitution, but the Constitution is what the president as commander-in-chief says it is. Recall Rossiter's statement that if Lincoln was a great dictator, he was a greater Democrat. This, I regret to say, is what still is to be determined with regard to the presidency of George W. Bush, who on almost every relevant measure seems less democratic than Abraham Lincoln with regard to having a candid conversation with the American people about the meaning of constitutional fidelity in the modern world. The global war on terror is defined in such a way as to make almost certain that it will never conclude, whether in my own relatively limited lifetime or even the lifetime of the youngest member of this audience. The emergency is then permanent. Claims of enhanced presidential authority with regard to emergency powers, however based, involve permanent changes in the conception of American government. What is dismaying is not the articulation about the need for more governmental, including presidential, power. Indeed, it is worth noting that the noted liberal Yale law professor Bruce Ackerman has himself written an article, The Emergency Constitution, that defends the propriety of congressional authorization and oversight of the state of emergency with concomitant suspension of some very basic constitutional norms for several months, subject, however, to more difficult congressional reauthorization. For Ackerman, a strong role by Congress is essential. There is much to be debated about the soundness of Ackerman's proposals, but in the main, what is truly dispiriting is the lack of a serious national debate led by national political leaders and not merely by a few law professors and others or editorialists for newspapers. The lack of a serious national debate by political leaders about the serious issues that are raised by the August 1, 2002 memorandum. The administration has chosen to engage in what might be called a strategic withdrawal of its arguments, and the Republicans who dominate the Congress are more than happy to participate in this charade. Democrats seem to be in a continuing state of shell shock. There are also the courts, of course, and Chief Justice Hughes' reminder that they must make their own independent determination about the presence of sufficient emergency to legitimate certain uses of state power. One might therefore take some comfort from the Supreme Court's willingness last year to reject some of the administration's arguments with regard to indefinite detention of American citizens in the absence of congressionally authorized suspension of habeas corpus. However, it is far too early to tell whether that represents a genuine willingness on the part of judges to stand firm against executive overreaching, or in contrast, the construction basically of a judicial fig leaf that will do little more than to legitimate significant incursions on any serious notion of due process of law. Justice O'Connor's opinion, to put it mildly, did not offer a very robust conception of the rights of suspected terrorists. More to the point, Justice Thomas's dissenting opinion was everything that Carl Schmitt or Clinton Rossiter could have hoped for with regard to giving the president effectively unlimited power to fight the war against terror. One does not know how many appointments the Supreme Court George Bush will get, though one might remember that William Howard Taft, in his one term at the beginning of the 20th century, was able to name 6 members of the court. And we do know that President Bush has publicly identified Thomas as one of his favorite justices. Even if President Bush does not name 6 justices, he may still have the opportunity to select just those judges friendliest to expansive readings of presidential power. Let me mention and conclude with one other reason for being fearful of looming presidential dictatorship. And this has nothing at all to do with the particular character of the Bush presidency. Imagine a terrorist attack on Washington that kills or disables, say, 250 of the 435 members of the House of Representatives and disables 51 members of the Senate. Would Congress still be able legally to function? I thus put to one side the obvious political and emotional issues I'm asking the question simply as a lawyer. And the very unfortunate answer is no. That is, Congress would not be able legally to function under the description I've given you. And the reason lies in one of the more technical aspects of the Constitution, the quorum rules, as set out in Article 1, Section 5, something I'm very confident has not been at the center of your own study of constitutional law. I confess I have never heretofore taught it. The quorum rule is, quote, a majority of each house shall constitute a quorum to do business, unquote. Ironically, the most serious problems arise if senators and representatives are disabled rather than if they are killed. If, after all, 250 members of the House are killed, then the membership of the House would consist only of the 185 survivors, and a quorum would be achieved if only 93 were present to do the work of the House. There would, to be sure, be profound issues of legitimacy if great national decisions were being made by a wildly unrepresentative small group of legislators, but that's a political problem, not a legal problem. One might obviously wish that vacancies be filled immediately, but that is impossible because the Constitution requires that all members of the House be elected. The news with regard to death is better with regard to the Senate, because under the 17th Amendment, should a senator die in office, the governor can immediately name a replacement. The problem arises if senators are only disabled. Since a quorum requires 51 senators, assuming 100 living members, it could easily arise that no constitutional quorum would be achievable, as would be true in the House as well, should a majority of its members only be incapacitated rather than killed. As a matter of fact, Texas Senator John Cornyn, a Republican, has proposed a constitutional amendment, itself the product of a bipartisan commission organized by the liberal Brookings Institution and the conservative American Enterprise Institute, that would rectify this potential threat to our constitutional order, a constitutional stupidity that I was simply unaware of when Bill Eskridge and I put together our collection of essays in 1998. As I said when testifying before a subcommittee of the Senate Judiciary Committee at Senator Cornyn's invitation, should we then be faced with a Congress that is unable for whatever reason to function, it is almost a logical and most certainly an empirical truth that power would flow to what can only be called dictatorship by a presumably functioning executive branch. After all, imagine the president believes that special laws are necessary in the wake of emergency. In our system, it is Congress that makes law. But if there is no effective Congress, then I dare say we would simply accept fiat rule by the president, the very definition of dictatorial rule. As we are told with some frequency, the Constitution is not a suicide pact. And there would be very few, I suspect, who would be sharply critical of a president who stepped into the breach and declared him or herself to be a Roman-like dictator. Alas, the proposed amendment is basically going nowhere, not least because the Republican chair of the House Judiciary Committee, James Sensenbrenner, is absolutely adamant that there be no modification of the principle that there are no unelected members of the House of Representatives. For all of Representative Sensenbrenner's otherwise commendable commitment to popular government, he is in fact making presidential dictatorship more likely. We are, I believe, at a crossroads in American constitutional development. The United States feels itself threatened by attack, and we have an administration in power that is stunningly ambitious with regard to its view of executive power. Yet it may be naive to look to the Constitution itself to resolve such dilemmas. Justice Robert Jackson spoke to just this point in what I believe is the single greatest opinion in our history, his concurrence in the Steele seizure case. What entitles it to that place for me is what I have elsewhere described as its completely adult tone. It is a serious, reflective essay written by an unusually able judge who, more to the point, had experienced government from multiple perspectives, ranging from President Roosevelt's cabinet to the Supreme Court of the United States to having been Chief United States Prosecutor at Nuremberg. He was a man of the law who was deeply aware of the limits of legal reasoning. For me, therefore, a crucial part of the opinion is his acknowledgement near the outset of his opinion that, quote, a judge, like an executive advisor, may be surprised at the poverty of really useful and unambiguous authority applicable to concrete problems of executive power as they actually present themselves. Just what our forefathers did envision, or would have envisioned had they foreseen modern conditions, must be discerned from materials almost as enigmatic as the dreams Joseph was called upon to interpret for Pharaoh. A century and a half of partisan debate and scholarly speculation, and today I would amend this to say 2 centuries of partisan debate and scholarly speculation, yields no net result, but only supplies more or less apt quotations from respected sources on each side of any question. And court decisions are indecisive because of the judicious practice of dealing with the largest questions in the most narrow way, unquote. What this means is that our resolution to issues of presidential authority in times of emergencies is a matter not of law in any standard model sense, but rather of what my friend and frequent co-author Jack Balkin and I have termed high politics. Or let me put it slightly differently. It should be high politics that inform our decisions, where high politics means precisely an elaboration of our most fundamental political visions for the collective enterprise and self-government that we call the United States of America. Instead, I fear that it is more and more low politics, which is making decisions by reference to the immediate consequences for one's own partisan interest, that drives our discussion. The central theme of my remarks, then, is not that the administration's views should be automatically rejected in the name of a rather simplistic notion that, quote, the president is not above the law. For better and worse, that is not what our constitutional history teaches us. Unless, of course, we are always willing to offer an understanding of law that basically becomes an apologia for the actions of at least those presidents whose policies we happen to like. Whatever one thinks of the specifics of Clinton Rossiter's constitutional dictatorship, he was attempting to initiate a deadly serious conversation about constitutional fundamentals. He failed, perhaps because it is too frightening to think about. The question is whether we can do any better now. Thank you.